Consequently, this claim is rejected. Fourthly, with respect to the allegations of errors concerning Strugar's failure in his duty to prevent the crimes, the appeals chamber dismisses without detailed consideration the arguments related to the command structure of the second OG because they are evidently unfounded. As regards the material ability to prevent the crimes, contrary to Strugar's assertion, the trial chamber did not identify it with the position he held within the command structure. For each of the findings it made concerning the de jure authority that Strugar exercised over the forces that participated in the shelling of the Old Town, the trial chamber relied on examples showing that the de jure authority he exercised within the second OG command structure also materialized in his de facto position of authority. Moreover, in the light of its other findings, in particular those related to the second OG structure and the means that Strugar had at his disposal to obtain additional information about the attack on Surge, the appeals chamber considers that the trial chamber's findings that Strugar failed to take the necessary and reasonable measures to ensure at least that the unlawful shelling of the Old Town be stopped were reasonable. Consequently, this claim is rejected.
Fifthly, regarding the alleged errors in respect of the events of 6 December 1991, the appeals chamber dismisses without detailed consideration Strugar's arguments with respect to his material ability to punish the crimes and to the promotions and decorations of persons involved in the shelling of the Old Town, because they are evidently unfounded. As regards his failure in his duty to take measures following the events of 6 December 1991, the appeals chamber is of the opinion that it was reasonable for the trial chamber to find that General Kadijevic accepted Admiral Jokic's suggestion to conduct an investigation into the events of 6 December 1991, and that the investigation conducted by Jokic turned out to be a sham. A majority of the appeals chamber, with Judges Meron and Kwan dissenting, is also of the opinion that Strugar knew that this investigation was a sham, and that he was not, in fact, excluded from the process of investigation conducted by Admiral Jokic. Accordingly, this majority finds that it was reasonable for the trial chamber to find that Strugar was at the least prepared to accept a situation in which he would not become directly involved, leaving all effective investigation to his immediate subordinate, Admiral Jokic, leaving action and decisions concerning disciplinary or other actions to him. Therefore, this claim is rejected. In view of the foregoing, the appeals chamber dismisses by a majority Strugar's first and third grounds of appeal. In his second ground of appeal, Strugar first submits that the trial chamber wrongly found that a superior-subordinate relationship existed. The appeals chamber recalls that the power of a superior to give orders does not automatically establish that this superior exercised effective control over his subordinates. But it is a relevant element to establish effective control. As the appeals chamber held in Halilovic, the orders in question must be considered carefully, while taking into account the evidence as a whole, in order to determine the degree of effective control wielded over the perpetrators of the crimes, the nature of the orders that the superior may issue, the nature of his position of power, and whether or not his orders are followed are elements to be taken into account when determining whether he had the material ability to prevent the crimes or punish the perpetrators thereof. In this regard, considering the nature of the orders that Strugar had the power to issue, the nature of the negotiations in which he was authorized to represent the JNA, those of his functions as commander of the 2nd OG, the fact that his orders were effectively followed and that the military justice system was still functioning at the material time, the appeals chamber finds that the trial chamber reasonably held that Strugar had the material ability to prevent the illegal shelling of the old town and to punish his subordinates. Consequently, the trial chamber correctly applied the requirement of the existence of a superior-subordinate relationship to the facts of the case. This claim is therefore dismissed. In the second prong of this ground of appeal, Strugar submits that the trial chamber made erroneous findings with respect to the mens rea of the crime of attacks on civilians and destruction or willful damage to cultural property, in particular as regards the findings on direct intent. The appeals chamber recalls that to be held criminally responsible, the perpetrator of an attack on civilians must have acted intentionally. In other words, the mens rea requisite of this crime is established when the acts of violence constituting the crime were perpetrated intentionally on civilians, that the civilians were targeted deliberately, or that the perpetrator of the acts was entirely indifferent to their consequences. As a result, this definition encompasses the concepts of direct intent and indirect intent referred to by the trial chamber and Strugar. As regard the mens rea for the crime of destruction or willful damage to cultural property, it is established if the destruction or damage targeted cultural property intentionally, that is to say, either deliberately or recklessly. In this case, in light of the evidence as a whole, the trial chamber was convinced that the perpetrators of the attack of 6 December 1991 acted knowingly, with the awareness of the consequences of their acts and wishing those consequences to occur. Strugar has failed to show how these findings were not reasonable. Accordingly, this claim is dismissed. In view of the foregoing, the appeals chamber dismisses Strugar's second ground of appeal in its entirety. As regards the prosecution's first ground of appeal, the appeals chamber considers that the trial chamber erred in law by not applying the correct test for the requisite mens rea under Article 7.3 of the statute, by finding that prior to the attack on Srce, launched in the early hours of 6 December 1991, Strugar did not know, or have reason to know, that his subordinates were about to commit a crime. More specifically, the trial chamber erred in considering that the fact that Strugar knew that there was a risk that his forces would illegally shell the Old Town was not sufficient to conclude that he possessed the requisite mens rea under Article 7.3 of the statute, and that for this he had to know that there was a substantial likelihood or a clear and strong risk that his forces would shell the Old Town. The trial chamber wrongly considered that the requisite mens rea under Article 7.3 required proof that the superior knew that his subordinates would very likely commit crimes. In this connection, the appeals chamber recalls that in order to hold a superior responsible under Article 7.3 of the statute, it is sufficient to prove that he knew that his subordinates could commit crimes. Having found that the trial chamber erred in law by applying the wrong legal test, the appeals chamber must apply the test that is appropriate to the facts found by the trial chamber and determine whether it is itself convinced beyond any reasonable doubt that Strugar had, prior to the beginning of the attack on Srce, a sufficiently alarming body of information within the meaning understood by the standard of had reason to know. According to the appeals chamber, the only reasonable conclusion in light of the trial chamber's findings is that, having been put on notice of the risk of an attack and alerted to the need to open an investigation, Strugar had reason to know, within the meaning of Article 7.3 of the statute, that his subordinates were about to commit crimes, but did nothing to prevent them. In view of the foregoing, the appeals chamber allows the prosecution's first ground of appeal. In its second ground of appeal, the prosecution submits that the trial chamber erred in refusing to enter cumulative convictions in respect of Count 4, devastation not justified by military necessity, Count 5, unlawful attacks on civilian objects, and Count 6, destruction or willful damage of cultural property. The appeals chamber notes that after finding that each of the offences theoretically contained materially distinct elements from each other, the trial chamber held that Counts 4 and 5 really added no materially distinct element given the circumstances in which these crimes were committed. The appeals chamber considers that by applying the Celibici test to the particular circumstances of the case, the trial chamber thus committed an error in law. Consequently, the appeals chamber revises the judgment accordingly and enters a finding of guilt for Counts 4 and 5. In view of the foregoing, the appeals chamber allows the prosecution's second ground of appeal. Finally, let us turn to the grounds of appeal on sentence as raised by both parties, Strugar's fourth ground of appeal and the prosecution's third ground of appeal. Strugar claims that the trial chamber erred in comparing his conviction with that of Miodrag Jokic, in failing to give the due weight to his apologies, and in failing to attach sufficient weight to certain mitigating factors. The prosecution submits that the trial chamber erred in comparing Mr. Strugar's conviction with that of Miodrag Jokic's, and in considering that the apologies presented by Mr. Strugar were a mitigating factor. As regards the comparison of Strugar's sentence with that imposed on Miodrag Jokic, the appeals chamber notes that further to its established jurisprudence, the comparison between the Strugar case and the Jokic case is only one of the elements the trial chamber took into account in determining the sentence. The appeals chamber considers that the trial chamber was correct to attach limited weight to the sentence imposed on Jokic. Indeed, for the appeals chamber, there are significant differences between the Strugar case and the Jokic case. The appeals chamber thus finds that the parties have failed to show that the trial chamber committed a discernible error in referring briefly to the Jokic case. As regards Strugar's statement at the end of his trial, the appeals chamber understands that the trial chamber considered that, in his statement, Strugar had expressed the pain that he felt for the victims and not the remorse he experienced. The trial chamber simply stated that it was convinced that the accused was sincere, expressly noting that it did not accept what was said by him in his last sentence. The appeals chamber considers that the trial chamber's finding on this point was entirely reasonable, on the understanding that at no time did Strugar acknowledge the moral blameworthiness of his acts. Finally, the appeals chamber considers that Strugar failed to demonstrate that the trial chamber did not take into account all the evidence before it when weighing these mitigating factors, or that it erred in its discretion with respect to the weight to give to mitigating factors. In light of the foregoing, the appeals chamber dismisses Strugar's fourth ground of appeal and the prosecution's third ground of appeal. This concludes the appeals chamber's examination of the grounds of appeal raised by the parties. I will now move to the analysis of how the appeals chamber's findings affect the sentence imposed by the trial chamber. Firstly, the appeals chamber found that the trial chamber had erred with regard to the scope of Strugar's criminal responsibility in failing to prevent the shelling of the Old Town of Dubrovnik. Although the appeals chamber in effect extended this responsibility from 7 o'clock in the morning to midnight on 6 December 1991, it considers, for the reasons set out in its judgment, that the trial chamber took into account the damage caused during this additional period. The appeals chamber therefore considers that this error has no impact on Strugar's sentence. Secondly, as regards the convictions entered for counts 4 and 5, the appeals chamber agrees, as the prosecution submits, that these convictions are based on the same criminal conduct and add nothing to the gravity of the crimes committed by Strugar. Finally, the appeals chamber notes that during the appeal hearing, the defense submitted that Strugar's health had deteriorated considerably since the trial judgment was rendered. The appeals chamber considers that it is competent to factor in evidence in this regard, given the fact that it must determine the sentence in connection with the errors found in the trial judgment. After examining the relevant evidence, the appeals chamber considers that Strugar's deteriorating health since the trial judgment was rendered must be considered as a mitigating factor. Consequently, the appeals chamber believes that it is good to impose a new sentence on Strugar. I shall now read the disposition of the appeals judgment. Mr. Strugar, please stand up.
Monsieur Strugar.
Mr. Strugar, I shall read the disposition. For the foregoing reasons, the appeals chamber, pursuant to Article 25 of the statute and Rules 117 and 118 of the Rules of Procedure and Evidence, noting the respective filings of the parties and the arguments they presented at the hearing on the 23rd of April 2008, sitting in open session, dismisses all the grounds of appeal submitted by Mr. Strugar, Judges Meron and Kwan dissenting, with regard to the third ground of appeal concerning the failure to take measures for the events of 6 December 1991. Allows the prosecution's first ground of appeal regarding the scope of Strugar's duty to prevent the shelling of the Old Town. Allows the prosecution's second ground of appeal and, pursuant to Article 7.3 of the statute, enters convictions under Count 4, devastation not justified by military necessity, a violation of the laws or customs of war under Article 3 of the statute, and Count 5, unlawful attacks on civilian objects, a violation of the laws or customs of war under Article 3 of the statute. Dismisses the prosecution's third ground of appeal, replaces the sentence of 8 years of imprisonment imposed by the trial chamber by a sentence of 7.5 years, subject to credit being given for the period already spent in detention under Rule 101 of the rules. Orders that, pursuant to Rules 103C and 107 of the rules, Strugar is to remain in the custody of the International Criminal Tribunal pending the finalization of arrangements for his transfer to the state in which his sentence will be served. Judge Shahabuddin appends a separate opinion. Judges Meron and Kwan append a joint dissenting opinion. Mr. Strugar, please be seated.
Monsieur le greffier, veuillez...
Mr. Registrar, please distribute copies of the appeals judgment to the parties.
Avant de conclure, je tiens à remercier...
Before concluding, I would take this brief opportunity to thank all of those who have contributed to the efficient conduct of this case and thank them for their constructive efforts. Thank you.
Merci.
These proceedings are adjourned.
All rise.